So good evening and welcome to the first lecture series event dedicated to the theory of punishment. My name is Paolo Carta. I'm a professor of history, political thought, and at the law school, and political theory at the School of International Studies, who happens to be the director of the Collegio Clesio or the University of Trento. When a student of Clesio asked me to launch this lecture series, I immediately thought it would be a dream to have John Bessler as our first guest. Therefore, on behalf of Collegio Clesio and the law school, I'm delighted to welcome Professor John Bessler to the University of Trento. Thank you very much for accepting our invitation to give a talk entitled The Lost Torturous Path from Torture and Barbaric Executions in Beccaria's Times to Universal Human Rights and the Death Penalty's Decline. I would also like to express my gratitude for accepting to be here in a moment when traveling is not easy and when we are still experiencing restrictions to hosting in-person events. Your presence here is a way to start restoring normalcy. John Bessler is a professor of law at the University of Baltimore School of Law and an adjunct professor at the Georgetown University Law Center. But he has also taught at the University of Minnesota Law School, the George Washington University Law School, and the University of Aberdeen in Scotland. He's a leading authority on capital punishment and an extraordinarily prolific author. Among his books, we can list The Death Penalty as Torture from Dark Age to Abolition, this one, published in 2017, and Cruel and Unusual, The American Death Penalty and the Founders' Eighth Amendment, published in 2012. And he also edited the book by US Supreme Court Justice Stephen Breyer, entitled Against the Death Penalty, published in 2016. However, the book that is always on my desk since 2014 is The Birth of American Law, an Italian philosopher and the American Revolution, devoted to the influence of Cesare Beccaria on the legal and political thought of the founding fathers. The Birth of American Law won the prestigious Scribes Book Award, the annual award given out by the American Society of Legal Writers for the best work of legal scholarship. And this book is also a fundamental step forward from a methodological standpoint, even for a scholar of Machiavelli, Richard Dean. John Bessler is the author of a splendid biography of Beccaria, the celebrated Marquise, an Italian noble and the making of the modern word, published in 2018. His most recent book is The Baron and the Marquise, Liberty, Tyranny, and the Enlightenment Maxim that can remake American criminal justice, published in 2019, which is not only a book about Montesquieu and Beccaria, two pillars of the founding fathers' thought. This book reminds us that our theory of punishment should be grounded in that Enlightenment principle, which stressed that punishment is proper only if necessary. Indeed, any punishment that goes beyond necessity is tyrannical, as Montesquieu and Beccaria emphasized. As John Adams wrote in his diary, every act of authority of one man over another for which there is an absolute necessity is tyrannical. Le pene che oltrepassano la necessità di conservare il deposito della salute pubblica sono ingiuste di lor natura. He wrote that in Italian, quoting Cesare Beccaria. These are just his most recent books, and I should also add many of his illuminated articles that I will circulate through the library website after the talk, such as what I think about when I think about the death penalty. And the abolitionist movement comes of age, the anomaly of executions, and his last article, his last book chapter entitled a tandem bicycle, the rule of law and the protection of human rights, just published in a book called Rule of Law, Cases, Strategies, and Interpretation, a book we were both involved in, edited by our colleague and a mutual friend at the Italian Academy of the Columbia University in New York City, Professor Barbara Faeda. John Bessler is also the author of a wonderful book about writing, published in 2007, Writing for Life, The Craft for Everyday Living, a precious book that I've read while I was at Columbia, and I hope it will be possible to reprint it because it costs too much now as a used book. If you check Amazon, you find that this book is sold at 1,900 euros. So I hope it will be reprinted soon because I think, and maybe translated into Italian, because I know for sure that many of my students will love it. But now it's time for me to stop and yield the floor to our guest. Please join me for a massive round of applause to welcome John Bessler.
Well, thank you, Paolo. I appreciate the invitation. It's great to be here. I've enjoyed seeing the city. You know, when now you have to get a COVID test within 3 days of departure. So when I was sitting at the airport on the morning of my flight, I wasn't sure if I was going to be coming to Trento or being in quarantine for 10 days. But luckily the test was negative. So here I am. I wanted to start out by saying a little bit about how I got into this work on the death penalty. So I grew up in a town in Minnesota, Mankato, Minnesota, which happens to be the site of the largest mass hanging in U.S. history. I think, you know, every community of any size, you know, has a history of having an execution or multiple executions. I was just looking this morning at Trento, and there was an execution here of Cesare Battisti in 1916. Was a very prominent Italian politician and was fighting against the Austro-Hungarian Empire. And so, you know, I think you could actually, in a lot of ways, you could map world history by looking at executions that have occurred. You know, there's executions after Nuremberg trials, which is the kind of the 1948 was the year that the Universal Declaration of Human Rights was put into place. Eleanor Roosevelt actually worked on that, the former First Lady of the United States. And in that document, there's actually no reference to the death penalty. There was some effort or some thought that the death penalty might be on its way out. And so they decided not to kind of mar the Universal Declaration of Human Rights with a reference to the death penalty, which you do find in the sort of the first covenant of international law, the International Covenant on Civil and Political Rights. You find that the death penalty is available for use for the most serious crimes, is the terminology that's used in the so-called ICCPR, which is the covenant of international law. And I'll talk a little bit more about that in a minute. But I grew up in Mankato, Minnesota. There was during the Civil War, there was a conflict between the Dakota Indians and the white settlers that were there, and there were several battles, and it led to a series of trials. They were military commission trials, and some of these trials only lasted like 5 minutes. And the upshot of it was there was over 300 Dakota Indians who were sentenced to death as a result of those military tribunals that took place. And Abraham Lincoln, in the midst of the Civil War, was asked to review those cases as the commander-in-chief leading the armed forces. It fell to him to decide what to do. He delayed it for quite a while. He ended up commuting a lot of the sentences. He did not execute 300 people, but on the day after Christmas, actually, December 26th, 1862, 38 Dakota Indians were hanged at the same time from a square wooden scaffold in what remains the largest mass hanging in US history. So that was just a few blocks from where I grew up. There wasn't really much of a marker there when I was growing up there was a no sort of reflection of what happened. There was a granite stone that was placed there that said 38 Sioux Indians were hanged here. That was the only thing that it said. And now there's a park, it's called Reconciliation Park, that recognized this actually was a conflict between two sovereign nations that took place in Minnesota. And so there's a park that's much more appropriately designed for that. But that's the history of where I grew up. And so I went out to law school at Indiana University and in Bloomington, Indiana, and studied the death penalty subject there in a seminar. And this was at a time when the U.S. Supreme Court was still allowing juvenile offenders to be executed. So there's been a lot of changes in American law with respect to the death penalty over the years, and I'll talk about some of those things. And obviously, there's been a divergence between Europe and the United States in terms of how the death penalty is treated by the law, and I'll again explore that as well. But I started studying this as kind of coming to it in a just as a, after finishing college, hadn't really thought much about the death penalty other than knowing that there was this execution that had taken place in my hometown. And again, most of the debate about the death penalty back then was focused on the issue of whether the death penalty deters crime. And this was something actually Beccaria was a pioneer on. He was studying this idea of, what's the optimal punishment to deter crime. He actually used algebra in terms of looking at the issue of smuggling. He wrote a paper about this using a formula, actually. So it's seen as a very foundational moment in sort of the law and economics movement, because it's applying sort of math to this idea of law. So I took that death penalty seminar, learned a lot about the death penalty, learned about how the representation of people on death row was really horrible in general. A lot of what we call in the United States ineffective assistance of counsel, people just not knowing how to represent people facing a capital charge. And so after finishing law school, I decided to work on some death penalty cases as a private practice lawyer. So in Minneapolis, Minnesota does not have the death penalty. We actually, in Minnesota, abolished the death penalty back in 1911. The last person that was hanged in Minnesota was a guy named William Williams. And when he was hanged, they had miscalculated the length of the rope. The sheriff had miscalculated the length of the rope. And so when he fell through the scaffold, his feet hit the floor, and the sheriff's deputies actually held up his body with the rope for 14 and a half minutes, and he strangled to death. And that was the way that eventually Minnesota abolished the death penalty in 1911, a few years after this kind of botched hanging. So Minnesota doesn't have the death penalty, but we have a lot of lawyers in Minnesota who've worked on death penalty cases, mostly in the South. There's a lot of states in the U.S. that still have the death penalty, but one of the things, if you look at it very carefully, is you see that the death penalty is dormant in a lot of states. It's not being used in a lot of places. So, for example, in California has a very large death row, but they haven't had an execution for many years there. Pennsylvania is the same way. A lot of people put on death row, but not a lot of use of the execution. So in some of these states, the death penalty has become sort of a symbolic thing, not really something that's used in practice, although the people on death row still face the prospect, potentially, of being executed. So when I was working on those cases, a couple of interesting cases that I worked on involved what are called private prosecutors. And I was talking to Paulo about this earlier today. I'm working on a book on this actually right now, the history of this. But in English law, the victim of the crime or the victim's family was actually responsible for prosecuting the offender. So they did not have a very developed system of public prosecution at that time. The Attorney General, which is a longstanding position in England, was actually a public position that was kind of the king's attorney. That goes back centuries, but only things that involved, like treason, where it was seen as an offense against the king or the queen, would involve the Attorney General. So in general, the families would be the ones that would be tasked with doing these prosecutions. And this was inherited in the United States. And so even today, there's actually a few states in the United States, like Texas, Kansas, Tennessee, where murder victims' families can hire a lawyer to assist the public prosecutor in seeking the death penalty in a death penalty case. So this idea of, the public prosecutor is supposed to serve the public interest, but you have this private interest that is coming in a life or death kind of situation and making decisions. The associate prosecutors making decisions, for example, about what evidence should be turned over, exculpatory evidence to the defense. And obviously, if the private prosecutor, the lawyer that's been retained, is being paid by the murder victim's family, their incentives are a little different than they would be for the public prosecutor who's being paid by the government to do their job. So in one case, there was a private prosecutor who was paid something like $90,000 in the course of that private prosecution. So I got a little bit of a taste of working on death penalty cases. The more I learned about the death penalty, the more I read about the death penalty, the more problems I saw with it. And I started writing about capital punishment. So the first book I did was way back in 1997. It was a book called Death in the Dark. And it looked at the practice in the United States of having executions 1 minute after midnight. This became a real tradition in the United States to schedule the execution for 1 minute after midnight. So it was kind of a strange thing. So I thought, well, I'll look into this and see why this is happening. So basically what it was is that there was a anti-death penalty movement that kind of rose up. A lot of people that witnessed executions saw them on the public square. And again, executions in Italy and in England, places like Tyburn was the place where people were hanged, or just public commons in the United States. Executions were generally conducted publicly. And so a lot of people were drawn to the anti-death penalty movement by the fact that they had seen these kind of horrific sights. And so as the anti-death penalty movement sort of began to take off, and Beccaria is sort of seen as the sort of the grandfather of the anti-death penalty movement. So there was some Quakers, people like John Bellers, who wrote against the death penalty back in his case, it was like 1690s. He was writing against the death penalty for thieves, for certain felons. It was unclear if he opposed the death penalty for everybody, but his writings were such that he certainly opposed the death penalty for certain categories of offenders. William Penn, who was the founder of Pennsylvania, who was also a Quaker, also had restricted the death penalty in what was called the Great Act of 1682. And so he limited the death penalty to murder, and then treason was also under English law a capital offense. So murder and treason were the only two offenses in William Penn's time. After he passed away, Queen Anne reinstated the death penalty regime in Pennsylvania, so it became a model on the English system again. The English system was known as the Bloody Code. So William Blackstone is a very famous jurist who taught at Oxford, described the melancholy circumstance of English law that made more than 160 offenses punishable by death. So if you go back all the way to Draco, and you think about draconian, right? The draconian laws. These were laws that made any offense punishable by death. And again, back in the medieval times, people didn't really have a place to put people who were offenders, right? So there was no modern penitentiary system like we have today. And so the solution that was offered by medieval thinkers was just execute everybody, regardless of the nature of the offense. And that was what was so, with Beccaria, there were some antecedents to Beccaria's work. So let me just give you a little bit of sense of Beccaria's, who was Beccaria? How many of you, just by show of hands, have read Beccaria? Any of his works? Okay, so a couple of you have. So for those of you who haven't, the book's been out for a while, so you could check it out. It's in many editions. But he wrote a book originally in Italian in 1764, and it was translated into French the next year, and then into English in 1767. And it was translated into English as an essay on crimes and punishments. So it was a study of crimes and punishments. And Beccaria wrote in that book about having a scale of crimes and a corresponding scale of punishments. So that was the central idea of the book. And Paulo had quoted from the famous maxim of Montesquieu that any punishment that goes beyond necessity is tyrannical. And so Beccaria publicized that maxim. And that was seen as the dividing line between liberty on one hand and tyranny on the other. So these were big ideas, right? Liberty and tyranny that these philosophers were talking about. And so if a punishment was anything more than what was absolutely necessary, that would be seen as tyrannical in nature. And so I think it's important for an Enlightenment foundation to think about that concept and to think to yourself, well, what is actually necessary? And if you applied that concept today to a lot of offenses that occur, it might not match up very well with that maxim. So the other thing that Beccaria did was he talked about torture. He wrote against torture, and he wrote against the death penalty. Now, he did that in separate chapters of his book. So one thing you see after the publication of Beccaria's book is that we have the first states that abolish the death penalty. So Tuscany becomes the first place where the death penalty was actually abolished in 1786. And then Austria also abolished the death penalty, except for crimes of revolt against the state the following year in 1787. So that was happening, at a very critical time. Now, the U.S. Constitution was actually debated in Philadelphia, and we have the Constitution agreed to in 1787 and then ratified the following year. We have the U.S. Bill of Rights in 1791, which includes the Eighth Amendment, which is the provision that prohibits cruel and unusual punishments, which has been the focus of so much attention with respect to the death penalty debate in the United States. That was actually language that was taken from another very foundational document. That was the English Declaration of Rights and the English Bill of Rights of 1689. So that English Bill of Rights of 1689, which was a product of what was called the Glorious Revolution in England. This also prohibited excessive fines, excessive bail, and cruel and unusual punishment. So the Eighth Amendment language was just kind of a mirror copy of the English Bill of Rights. And the idea, I think, was that if the English had these rights, then the Americans should have those same rights. They're seen as ancient rights of the legal system. And so, in thinking about kind of the progress that has been made since the days of Beccaria and these early Quakers who thought about the death penalty, and the Quakers had critiqued the death penalty more from a religious standpoint. A lot of their writings were about God and interpretations of the Bible. When you get to Beccaria, it's more of I would say more of a secular look at kind of these principles like proportionality and looking at ways in which the death penalty simply was not rational at that point, that there was other ways to deter crime that were more effective than the death penalty. Now, the alternative that was offered in those days was not exactly progressive in nature. So Beccaria talked about perpetual slavery. That was the alternative to the death penalty. So, think about that today, right? Perpetual slavery. Actually, in the U.S. Constitution, in the 13th Amendment, which was the amendment that Abraham Lincoln pushed for to abolish slavery, that was ratified in 1865 in the wake of the U.S. Civil War, which claimed hundreds of thousands of lives. There was a provision that 13th Amendment abolished slavery and involuntary servitude, except for the punishment of crime. So it has a provision in there that kind of echoes Beccaria's work. Beccaria is not mentioned in that debate, but that was the intellectual history that kind of led up to that moment, which is kind of an interesting kind of historical footnote at this point. So in terms of thinking about this issue of the death penalty, I mentioned this mass hanging that took place in Mankato. One of the Indians, a man named Chaska, was actually hanged by mistake. During the course of the war, Chaska had actually saved a white woman from being killed during the war. Her name was Sarah Wakefield, and in the wake of the execution, she learned that he had been hanged by mistake. They'd only identified the Dakota Indians by number of the files that they had. And so he was executed, and she was distraught about this, and they immediately confessed that it was a mistake. They simply hanged somebody by mistake. So the issue of errors with respect to the death penalty has been with us for a long time. I know in Italy there was mistaken wrongful executions as well, and this was something that was talked about as well as a risk for the use of the death penalty. But when Beccaria wrote his book on crimes and punishments, it became a really popular book in the United States. And in this Birth of American Law book, I write about all the ways in which that book influenced the American legal system and American thought. Beccaria actually never got to the United States, never visited, but there were Italians that did visit the United States in this foundational period before the Constitution was debated, the Bill of Rights was ratified. One of the people that visited was somebody from Milan. It was a botanist, Luigi Castiglione, visited the United States, did a grand tour. He visited all the states at that time in the U.S., went to Canada, and he had discussions about, and he wrote this Viaggio, a travel journal, which was later published in Italian and then ultimately into English, but not until like the 1980s. It was very long after that his work became available in English. But in that translation, I found that there was references to Beccaria. So one of the people that he talked to was a man named William Bradford. William Bradford was the second Attorney General of the United States, the top legal officer in the United States. And when Luigi Castiglione was in the United States, William Bradford gifted him an edition of Beccaria's book on crimes and punishment that had been published in the United States. So the On Crimes and Punishments book was actually widely translated in many different languages, published in many different editions, including in English, and had this big impact. So if we look at some of the key American founders, we see George Washington and Thomas Jefferson both bought copies of Beccaria's book in 1769. So before even the Declaration of Independence was signed in 1776. We see John Adams, as was referenced, read the book in Italian, as did Thomas Jefferson. Actually read the book in Italian, actually copied many passages from the book in his what lawyers called a commonplace book. That's how lawyers learned back then. They would copy significant passages from books into their own book. They didn't have photocopiers back there, at that time, right? So they had to find a way. So that's what they did. And he copied a lot of provisions from the book in the original Italian. And one of the things I learned was that there was many people that were reading this book. Benjamin Franklin, you see James Madison, John Hancock, who famously, his signature is a big signature on the Declaration of Independence, read Beccaria's work as well. John Adams actually quoted from Beccaria's book at the Boston Massacre trial. This was a trial that took place in 1770, and he quoted a famous line from Beccaria's book and about saving somebody from the punishment of death. And he actually did save Captain Preston from the punishment of death in that case, who was the British soldier that was put on trial. And a spectator described the reading of this passage from Beccaria's book as having an electrical effect on the spectators. So this is a book that was widely read. I found evidence that there was law students at Yale in Connecticut that were reading Beccaria's book. It was reprinted in a newspaper there in 1786. So at the very time that the U.S. Constitution was being thought about, drafted, we have all these Americans reading Beccaria's book. And so, this is sort of the beginning of this international movement to abolish the death penalty. Starts in Tuscany, right? Austria. Beccaria's book becomes the intellectual impetus for this. My recent work has focused on thinking about, is the death penalty torture, actually? So in Beccaria's time, the death penalty was conceived as something other than torture, because the fact that he was writing about the death penalty and torture in separate chapters shows that there was a different thought about that. And a lot of countries that were abolishing torture during the Enlightenment, and you have, countries like Sweden and, I think Austria abolished the death penalty in the 1770s. They weren't always at the same time abolishing the death penalty. A few of these countries, did have some sort of, connection, but a lot of the countries that abolished torture did not at the same time abolish the death penalty. And I think it's important to remember sort of the origins of the idea of torture in this discussion. So torture was actually something that was judicially authorized. So judges were ordering people to be tortured for purposes of eliciting information to get the truth or to discover who the accomplices were. So the use of torture was seen to be used in the civil law system. So the civil law system in continental Europe authorized the use of torture, but they were trying to get at the truth, and they were trying to discover accomplices. Beccaria said, this is not going to help you get the truth. It's just going to punish people that are innocent and inflict pain on them in this process. So the English system, by contrast, the common law system was one where they said, well, we don't use torture. The common law doesn't authorize the use of torture. Now, the royal figures, the monarchs, would authorize the use of torture. So if you go to the Tower of London, you'll see that they did use torture in England. They had the rack and the thumb screw, these types of devices of torture. So they were using torture, but they were just doing it kind of outside the normal aspect of the law. And again, it's important to remember back then, this theory that the kings had, right, to support their regimes, was this idea of the divine right of kings, that they could do whatever they want. They were basically deity-like figures, right? That whatever they did was just what God willed. So the kings could use these kind of extraordinary torture warrants back at that time. So even though torture was seen as forbidden by the common law, it was still used really throughout the world. And I think if you look at the devices of torture and the methods of execution that were used back in Beccaria's time, it's a list of sort of the most grotesque kind of things you can think about. So drawing and quartering of people, people being burned at the stake, in some Asian locales, people were using death by 1,000 cuts. They were literally sawing people in half in different places in medieval times. And so these kind of grotesque uses of the death penalty came to be seen as problematic. And we have some thinkers during the Enlightenment that were, like in France, for example, Dr. Guillotine, who's associated now with this killing device, right, was actually opposed to the death penalty, but he was trying to find a way to make punishments more equal. And this idea of equality was something that Beccaria was also much known for. And in fact, the year before the start of the Revolutionary War in the United States, the war starts in 1775 and runs till 1783. In 1774, the Continental Congress, which was the body that was the sort of the breakaway from England, quoted Beccaria in a letter to the inhabitants of Quebec, in what is now Canada. And in that letter, Beccaria's words were quoted as, in every human society, there's a continual tendency to elevate some to the height of happiness and to reduce others to misery. And Beccaria said the intention of good laws is to oppose that effort and to diffuse their influence universally and equally. So universally and equally. So applying the same punishment to everybody. So the idea of the guillotine was that everybody, from somebody who was considered to be in the lower class to the highest class, the aristocrats, would be punished in the same way. Now, when we think about universal rights, we think about the Universal Declaration of Human Rights. That's the first instrument that really articulates and lays out all these various universal rights. And there's several articles. I think there's more than 30 articles that are in the Universal Declaration of Human Rights. Of course, prior to that, we have kind of the ideas of natural rights, that everybody who's born has certain rights. This is kind of a concept that Rousseau and others explored, that just by fact of being born and being human, you have certain rights. Thomas Paine, who was the American revolutionary, who also went to France and argued against the execution of Louis XVI, actually, in France, wrote in his book that in America, the law is king, whereas in other places, the king is the law. So that was the shift that was seen from moving away from this idea of the divine right of kings to a system based on laws. John Adams, who was mentioned earlier, who was the second American president, actually in the Massachusetts Constitution of 1780, which is the first, actually the longest standing constitution, other than I think San Marino has this very old constitution, but that state constitution in Massachusetts actually predates the U.S. Constitution. And in that Constitution, Adams says that he has a provision about separation of powers for the executive, the legislative, and the judicial branch. They have to be separate. But there's also a line in there about how there's going to be a government of laws and not of men. And by that he meant that the law should govern, not individual arbitrary decision-making of individuals. And this is something also that Beccaria had talked about in his book. He had a whole section of his book about an interpretation of the laws and how you want to have the laws be applied and have the laws be very clear, so that the judge, all the judge has to do is just look at the facts, look at the law, and then make the decision. Is the person guilty or innocent? If the law was that clear, the judge would, as Jefferson described it, become a mere machine, would just look at the law, look at the facts, and apply it. Now, we all know that's not so easy to do, but nonetheless, that was the idea. So I want you to keep in mind this idea of universal rights, and that's something, again, that goes all the way back to Beccaria's thinking and was promoted in the United States by people that were proponents of Beccaria's work, and were people like Filippo Mezzè, was a neighbor of Thomas Jefferson, was an Italian who came and actually wrote about liberty before Jefferson wrote his famous Declaration of Independence. He hasn't really gotten enough credit, I don't think, for his influence on the American founding, but he was somebody that really viewed himself as both Italian and American in some ways, and wrote a history of the American Revolution when he went to France afterwards. So in thinking about the death penalty, I think we need to reconceive the way the death penalty is thought of. And so one of the things that I've been thinking about lately is thinking about, well, what is torture? Now, in the past, torture was seen as something that was inflicted on the body of the person. So, back in the Inquisition, inflicting severe physical pain on the person. That was the idea behind the idea of torture. So if you subject someone to physical pain, they will give you information, or they will, do something else, disclose an accomplice to a crime. That was the idea. So the use of these devices of torture, which you could see, if you looked at museums around the world where these instruments of torture were used, that was the idea. The modern conception of torture, however, is different. The modern conception of torture is that torture can be both physical, but it can also be mental or psychological in nature. And if we look back at the sort of the development of this, like the Third Geneva Convention, I think it was in 1949, actually included a section in there that referenced mental torture, mental or physical torture. When the UN Declaration Against Torture was adopted, it also prohibited both mental or physical torture. The UN Declaration Against Torture led to the UN Convention against torture and other cruel, inhuman, or degrading treatment or punishment. And so Article 1, the very first article of that convention, prohibits the infliction of severe pain or suffering, mental or physical, for a prohibited purpose. One of the prohibited purposes is punishment. Okay, so in international law at the current time, there's a prohibition against not only physical torture, but also mental torture. And I think that the idea of mental torture has not been conceptualized enough at this point. And let me explain a little bit about why I say that. First of all, it's important to remember that in the modern era, we've now seen a movement away from non-lethal corporal punishments. So at one time, right, it was very common for people to be whipped. It was very common in England for people to have their ears cut off. They called it ear cropping. People would be put in the pillory, in the stocks. They would have things thrown at them. These kinds of punishments were abandoned. And so we have a situation right now where non-lethal corporal punishments are no longer in use, including in US prisons. There was a case actually that was decided in 1968. It was a case, Jackson versus Bishop. This was a case actually written by Harry Blackman, who's actually from my home state of Minnesota. He later got elevated to the US Supreme Court, but while he was on the US Court of Appeals for the 8th Circuit, he wrote an opinion as an 8th Circuit judge, looking at the use of the lash in Arkansas prisons. And he wrote back in 1968 that the lash was both degrading to the person being punished and to the person that was inflicting the punishment, and declared that the use of the lash was a violation of the US Constitution's 8th Amendment and its cruel and unusual punishments clause. And by the way, that the High Court in England now has said that the death penalty violates the prohibition against cruel and unusual punishment. So the very language that the Americans adopted from the English is now, under English law, the death penalty is not permitted under English law, even though the Americans are using this exact same language that they got from the English legal system. And South Africa actually used a similar provision to declare the death penalty unconstitutional back in the mid 1990s in a case called State versus Makwanyani. So a lot of countries are abandoning the death penalty. Sierra Leone just abolished the death penalty. I think became the 23rd African country to abolish the death penalty. We've had Mongolia. Lots of countries around the world have abolished the death penalty. But there's still the death penalty being used in a lot of places. The modern campaign to abolish the death penalty, has its origins with Beccaria's work. But I would say that there was a turning point in the 1970s. Amnesty International, which had initially just opposed prisoners of conscience who had spoken out in some way in authoritarian regimes from being put into prison, but they expanded their work. In 1977, they had a conference, and they came up with this what's called the Declaration of Stockholm, which declared that their absolute abolition to the death penalty, and declared that the death penalty was the sort of the worst kind of cruelty and amounted to torture. And so they started this campaign to eliminate the death penalty. Now we have a World Congress against the death penalty every 3 years. We have the UN General Assembly every couple of years passing a resolution calling for a moratorium on the death penalty worldwide. But we're still seeing, China, we don't know what the statistics are. They don't keep statistics on the death penalty. It's considered a state secret. A lot of people think there's probably, over 10,000 executions per year, maybe, that are occurring in China. But we have, countries like Yemen and Iraq, Iran, where people are still being, hanged publicly. They're actually in Iran using, construction cranes to hang people. And so there's a lot of places around the world are still using the death penalty. But if you actually look at the countries that are most frequently using the death penalty, for the most part, it's kind of a rogues gallery of people that have countries that have really enormous human rights violations in many other areas. Look at Saudi Arabia, which is still using the death penalty. Women's rights there are not respected. And so, the idea of the death penalty in modern times, the only industrialized countries that are highly industrialized countries that are still, using it, Japan, infrequently using it, but still has it on the books. There, it's actually used in a very secretive manner. The families of the death row inmates are not told of the execution until after it occurs. And the person that is subject to the execution doesn't find out that they're going to be executed until the day of. They're told this is the day you're going to be put to death. So that anxiety of awaiting execution is constantly there for anybody who, and there a lot of people have been spending, more than 1 decade on death row in Japan. In the US, the average time that people spend on death row is now about 15 years, been climbing over time. And so the European Court of Human Rights had decided a case back in 1989 called Soaring versus United Kingdom, which that case was there was a young man who was accused of murder in Virginia, and the European Court said you could not extradite him to the United States because he would face the death row phenomenon. And that death row phenomenon is the idea that if you spend a lot of time on death row, you will be subjected to this kind of severe anxiety, fear, and so it's inappropriate to use the death penalty in that context. So there's other places in the world that have also referred to the death row phenomenon and have put that in their legal system. But in the United States, the US Supreme Court has yet to take up a case that would consider this issue of the death row phenomenon, even though Justice John Paul Stevens, when he was on the court, Justice Breyer, and Justice Ginsburg, who just recently passed away, as we know, all had called for the US Supreme Court to review that. But in the United States, you need 4 justices to get the Supreme Court to review a case. So they haven't yet had 4 justices willing to take up that issue in the Supreme Court forum. If you look at the Convention Against Torture, I want to come back to that for a second, because we know that it prohibits both mental and physical torture. So we look at the death penalty. What are the characteristics of the death penalty? The death penalty has certain immutable characteristics. You can't change the fact that when you use the death penalty, you are going to be charging somebody with a capital crime in a legal system. So you're going to be putting them a notice that you're going to seek the death penalty. So the capital charge is there. The capital charge, in my mind, is kind of equivalent to a death threat. It's a state-sanctioned death threat. So it's the state saying, we are intending to try to put you to death, right? A death sentence is a much more credible death threat because now the death sentence has been imposed on somebody. And so it's again, a threat. It's not saying you're not necessarily going to be executed. We know there's a chance you might not be executed. There could be some reprieve that's done, but a death sentence amounts to a state-sanctioned death threat. And as the execution date approaches, the death threat becomes more and more real. It becomes more and more imminent day by day as it gets closer and closer to the execution date. And if we look at the definition of psychological torture, there's actually some really interesting case law, ironically, in death penalty states that talks about what amounts to psychological torture. Now, going back just a little bit, in the United States, there's been US Supreme Court decisions saying that torture violates the 8th Amendment to the US Constitution. Ironically, these were cases where the US Supreme Court approved the use of the electric chair and approved the use of the public firing squad. These were cases that were decided in the Inmate Kimmler case. That's a case from 1890 that upheld the constitutionality of the electric chair, and the case that was decided on the public firing squad, that was a case from the 1870s. But in those cases, the court says that the use of torture or a lingering death is against the 8th Amendment. So the US Supreme Court's recent case law, going back to these early cases, has focused really solely and exclusively on whether there will be this excruciating physical pain at the moment of an inmate's death. So does the lethal injection protocol, will that lead to the risk of excruciating physical pain? The US Supreme Court has in a series of cases has approved the use of various lethal injection protocols. There was a case, Bays versus Kentucky. There's a Glossop versus Oklahoma. There's a case involving an inmate named Bucklew, where the U.S. Supreme Court has approved the use of lethal injection protocols. Justice Sotomayor, in her Glossop dissent, actually described the risk of one of these protocols. If the first drug doesn't work properly, she said that there could be a risk of searing pain at the moment of execution that would be tantamount to being burned at the stake, essentially. That's what the language that she used. But again, the Supreme Court is really using this language of physical pain and suffering at the moment of death. Okay. Now, in these death penalty states, there's a few states that have defined psychological torture, not for purposes of international law, but for purpose of deciding if a murder is aggravated enough to warrant the use of the death penalty. So in death penalty states, the Supreme Court U.S. Supreme Court has said that certain categories of offenders are not eligible for the death penalty. And there's a number of sort of exceptions that have been made where the death penalty cannot be used. So now the Supreme Court has outlawed in Roper versus Simmons case, it outlawed the use of the juvenile death penalty. So people under 18 can no longer be executed in the United States. In a case called Atkins versus Virginia, and a subsequent case, the Supreme Court made clear you can't execute those people with intellectual disabilities. In a case called Enman, the court said, well, you have to have played some sort of serious role in the crime. You can't just play a minor role in a crime and be subject to execution. And there's other cases where the court says, well, if you don't have a rational understanding of the reason why you're being put to death, you can't be executed. So there's a number of exceptions where the court has said it's unconstitutional to use the death penalty in certain circumstances. The same is true for certain kinds of crimes. That's U.S. Supreme Court has said actually, Ruth Bader Ginsburg had written a brief for the American Civil Liberties Union saying back in the Coker versus Georgia case prior to that, those that committed where there was not a homicide associated with the rape, it would be disproportionate to use the death penalty in that situation where no death had occurred. She actually wrote in her amicus brief about how the law had so mistreated women that women were seen as the property of men. And so that when people were executed in the past for rape, it wasn't to vindicate the woman's rights, it was to vindicate the rights of the father or the husband. So she had written that and had opposed the death penalty and successfully wrote that brief where the Supreme Court declared that the death penalty could not be used in situations where there was no murder that had taken place in the course of the rape. That decision was, like from 1977, and the Supreme Court has also said you can't execute those who are insane. You can't execute those who've kidnapped somebody where there was no murder that occurred. So there's a number of cases where the court has restricted the category of offenders who can be eligible for the death penalty, and has said that you can't execute certain offenders for certain crimes, basically. Now, in these death penalty states that are using the executions still today, like Alabama, there's case law in Alabama that defines psychological torture for purposes of deciding if there's a torture murder, then that could be eligible for the death penalty. So the Supreme Court has made clear you have to have an individualized determination of whether somebody is subject to being executed. So you have to look at the context of the crime, et cetera. And so there's a number of states that have passed laws that describe particularly cruel or atrocious murders that make somebody eligible for actually the death penalty in those states. One of those things is the infliction of psychological torture in the course of a murder. So in Alabama, in cases like Ex parte Deardorff, it's a state Alabama State Supreme Court case. The Supreme Court, state Supreme Court in Alabama says, well, psychological torture is the awareness of one's impending death and the helplessness to prevent that death. So it's the awareness that you're going to die and your inability to prevent that death. So if we apply that same definition of psychological torture, now again, that's that's in what I call the non-state actor context. So the Convention Against Torture only deals with official acts. It's where the government does something. Now, if the government were to condone something else that somebody else was doing, then they could be complicit in that, and they may have some obligation to protect somebody from being tortured, right? If they're aware that somebody's going to be tortured, they have certain obligations under the Torture Convention. Actually, the Torture Convention does a couple of things. One, it requires you to criminalize torture. You have to have laws that prohibit torture. It also precludes people from extraditing somebody or sending somebody to another country where they might be tortured. So in a lot of, like in the United States, in a lot of asylum cases, one of the issues that might come up is, are you going to send somebody back to a country where they might be tortured? And if they are, then they can get asylum and be protected from that torture. So there's other contexts as well where we are very concerned about kind of the use of death threats. So I teach, for example, I teach contract. I teach civil procedure and contracts. So I teach some sort of basic first year courses in law school. And one of the cases that I teach involves a situation where there was a transfer of property that was being challenged, and it was a husband and wife who were splitting up, and the wife's father was actually in prison for running an arsenic poisoning ring. And he had made there'd been some threat that, look, if you don't transfer all your property to, you might end up the victim of this arsenic poisoning scheme. And in that case, the court said, well, maybe that's duress. And maybe we should look at this transaction to see if there was actually free will in entering into the transaction. So where there is a threat of death, that is seen in and I've done a lot of civil litigation, that would be seen as something that would not bind you from that in that contract. So if somebody puts a gun to your head, that's a classic example of duress, and no court would enforce a contract where somebody made you sign the agreement where you had a gun to your head. Now, in the death penalty context, we have people, making these capital charges. And again, sometimes there's plea agreements entered into where somebody will plead guilty in exchange for the government removing the death penalty from the equation. Again, does somebody have the free will to make that kind of decision when they're facing a death penalty charge, which again, sort of amounts to a death threat in that sense, and a serious one, a credible one, because it's backed by enormous state power. So if we look back at this case law from Alabama that's out there, and there's other states as well that have similar discussions of what psychological torture is. And again, it's important to remember this is in the non-state actor context. But in terms of law, if you have a definition of psychological torture for one purpose, you might ask yourself, well, why not have that same definition for this other purpose, right? And an aspect of torture is that, there is a helplessness to it. That's what makes it such an aggravated form of cruelty. And one of the things I think is really interesting when we think about the death penalty is that, and we try to conceptualize what the death penalty actually is that a mock execution is already considered a classic example of psychological torture. So what is a mock execution? That's where someone's led to believe that they or maybe a family member is about to be killed. And so, like the US Army Field Manual prohibits the use of this. This is seen as, if you look at the textbooks, it's seen as a classic example of psychological torture. So if a simulated or a fake execution is already considered psychological torture, then what about a real execution? What about a real execution that basically is a mock execution, but then they actually kill the person, right? It's just more severe. So I think we need to reconceptualize how we think about the death penalty in that way. And if you think about actually death threats in general, death threats are already considered to be illegal. And I don't know what the Italian law would be on this point, but I imagine that there's a provision of law that says it's illegal to threaten somebody with death. These are pretty universal laws that are around the country that are designed to protect people from that fear of death. And in fact, in the U.S. legal system, there could be tort claims, for example, intentional infliction of emotional distress. You could have again, I talked about the asylum context where could be an element of past persecution that could be considered in an asylum claim. And we do also have case law in the United States about interrogations. We don't want to have coerced confessions, right? So if somebody confesses to a crime and they have a gun to their head, that would be considered a classic example of a coerced confession. But yet, at the same time, we don't have the death penalty being abolished yet in the United States, even though we have the threat of death being used as really an immutable characteristic of the death penalty itself. You can't have the death penalty without having the use of death threats in that process. And so there's this kind of brings me to the idea of the universal human rights. So we talked about the past. We talked about the use of these severe punishments, methods of execution. We've talked about how non-lethal corporal punishments are already seen as being violative of human rights and could be seen as torturous in nature. And then we get to the death penalty. And so there's actually, in the Universal Declaration of Human Rights, it says no one shall be subjected to torture or to cruel, inhuman, degrading treatment or punishment. We have the same provision. It's actually in the International Covenant on Civil and Political Rights. No one shall be subjected. Now, as I mentioned, the ICCPR in Article 6 says that the death penalty can be used for the most serious crimes. But there was a suggestion in that convention that it says for countries that have not yet abolished the death penalty. So there was a thought that the death penalty was kind of on its way out. This was back in the 1960s when this convention is put in place. In the Inter-American system, the American Convention on Human Rights actually includes a provision that once a country abolishes the death penalty, they can't reinstate it. It's a one-way ticket. Once you abolish, you cannot reinstate it. So that the idea of that was, I think, was a recognition that countries are going to be moving towards abolition. And that's the ideal situation, is to have a complete abolition of the death penalty. And we're seeing around the world, as I talked about, a lot of countries are moving away from the death penalty. And when we look at the Convention Against Torture, I described the definition in Article 1. The definition, again, is infliction of severe pain or suffering, mental or physical, for a prohibited purpose, one of which is punishment. Now, in that same article, at the very end, it says there's a lawful sanctions exception. So there's a carve out that says basically torture is not things where we have the infliction of punishment for as a lawful sanction. Now, I want you to think about that for a second. So obviously the clear intent of the Torture Convention is to abolish and end torture, end cruel, inhuman, degrading treatment or punishment, all of those things. But they have this carve out. Now, the carve out was put in there. Again, we look at certain countries who use, like in the Middle East, there are certain countries that still use things like amputations of limbs as punishment. Those countries have signed on to the Convention Against Torture. There's been some countries in Europe who've actually objected to say, look, if you're going to join this convention, you should also change your laws when you're doing it to conform to this idea that we don't want to have people using torturous practices who are actually signatories to the UN Convention Against Torture. Now, when the US ratified the Convention Against Torture, it took quite a while for them to ratify the convention through the process that they have to use there. But they signed, entered reservations that said that they could still use the death penalty, essentially. But there was part of the resolution was that nothing that could be done could violate the object and purpose of the Torture Convention. Now, under international law, there's a treaty on treaties called the Vienna Convention on Consular Relations, which is says that when you sign on to a treaty, you're not supposed to violate the object and purpose of the convention. So I would argue that torture has certain immutable characteristics to it. The definition that's used in these death penalty states that, you know, an awareness of one's impending death and a helplessness to prevent that death. I think that's a pretty good definition of what psychological torture is. And if we apply that and we think about the death penalty, we think this is torture on steroids, because you are subjecting someone to this threat of death and the awareness of their impending death, not just for minutes or hours or days, but literally for more than a decade in many cases. There was one inmate, Justice Breyer wrote a dissent in a case where the person had been on death row for, I think, over 40 years. I think in that opinion, he talks about how, you know, the Berlin Wall was coming down, and we have, you know, this person still on death row. So in thinking about the lawful sanctions exception, we now know that the death penalty is not lawful in a lot of places. In Europe, where it's really been leading the way, we have the amendments, the protocols to the European Convention. Protocol 6 abolished the death penalty during peacetime. Protocol 13 abolished the death penalty during wartime. So you have an absolute prohibition. The only place in Europe that's still using the death penalty is Belarus, I think, is still using the death penalty. And again, that regime, right, has been subject to a lot of criticism for the way it's operating. So in Europe, it's sort of a death penalty free zone. A lot of the, you know, and there's been this refusal to extradite as well. I know in Italy, there's been this decision not to extradite somebody where they would face any prospect of the death penalty. They're just not going to do that, which kind of mirrors in a way actually the torture convention, which says you can't extradite people if they're going to be tortured. So this idea of refusing to extradite when there be subject to the death penalty, it has a lot of parallels to the actual requirements of the torture convention. So if we think about the idea of universal rights, the idea of the rule of law itself is that everybody is subject to the same laws, but the converse of that is everybody's also entitled to the same protections. So if in the international system or in a domestic legal system, you're willing to say, well, we can torture some people because they did really bad things in the past, then you don't really have universal human rights. You have almost universal human rights, maybe, but you don't have truly universal human rights. And actually, when you're thinking about the use of torture, right, what somebody did in the past is not relevant to whether this act at this moment in time that's being done is actually torturous. And there's actually clear case law in the European Court of Human Rights on this point that says no matter what somebody did in the past, that cannot be used as a factor in deciding whether or not somebody's going to be subjected to torture or other cruelty in the present moment. And I think if you think about that, it makes perfect sense that to analyze whether somebody's engaging in torture, you have to look at what you're doing right now in that moment. And so when we think about the lawful sanctions that sort of carve out, you know, in the United States, we have a number of American states that do not permit the death penalty, where it's already been abolished. We have a number of others where it's kind of dormant, as I mentioned. And then we have a lot of countries around the world where it's no longer a lawful sanction. And so if we think about the death penalty and the immutable characteristics of the death penalty, and we think to ourselves that this actually does constitute torture, because in other contexts, death threats are seen already as torture if they're credible death threats, mock executions being the prime example, then we have to be thinking about reconceiving how we think about the death penalty. And so when Beccaria was writing about the death penalty and torture, he was writing about them in separate chapters. I would argue that we should be thinking about torture as a broad concept, and then think about non-lethal forms of torture and lethal forms of torture, such as the death penalty. And so, you know, my sort of wish is that the international legal system moves towards a absolute prohibition against torture. We already have, I don't know, how many of you have studied international law at this point in your careers? So do you know the jus cogens concept? Yes. Okay, so what does the jus cogens concept tell us? If I can call on somebody like I would in my law school. Jus cogens means that the
principle of law is universally recognized by all the states as something that has to be respected. Yeah, not be changed.
Can't be changed. So it's compelling law, and it's you can't deviate from it. There can be no derogation from it. And so when we think about what's already seen to be by international law publicists as being jus cogens norm, we see things like, slavery is absolutely prohibited. We see, the idea of genocide being prohibited. There's a number of things, but torture is one of those things. And in terms of thinking about torture, if the death penalty was just reconceived as torture, we already have a jus cogens norm prohibiting torture, which would mean that places like China or countries that are using the death penalty on a more regular basis would be forbidden by international law to engage in that practice. There's also some interesting implications for this as well. So, in terms of the idea of universal jurisdiction, torture is also seen as one of those crimes that would be subject to universal jurisdiction. So the whole idea of torture is that it's a particular stigma that's attached to a particular act because it's so severe in nature. And so after doing this research, the death penalty has so many flaws to it. It's always been administered in a racially discriminatory fashion. If you look at the history of the United States, it was often used against enslaved people, execute them after slave rebellions took place. The death penalty has never been applied fairly in the United States. It's also become increasingly arbitrary over time, and there's actually a prohibition in the International Covenant on Civil and Political Rights about arbitrary executions as well. So if you look at the administration of the death penalty, it's become this incredibly arbitrary punishment. Who gets the death penalty? In the United States, there could be 15,000, 20,000 murders every year, and you see the death penalty being inflicted in less than 50 cases, maybe, in the United States. So it's incredibly arbitrary, and that's one of the things that Justice Breyer, in one of his dissents, said in this Glossop versus Gross case, which I had the chance to write the introductory preface leading into that opinion to try to better publicize what he said there. But if you look at the use of the death penalty, it's incredibly arbitrary. It's applied in a racially discriminatory fashion. There's been study after study that showed that. But in addition, this immutable characteristic of the death penalty is it involves the use of death threats. And you simply can't change that. So even if you could guarantee that the death penalty would be inflicted in a physically pain-free way, which there's not really a lot of evidence to show that, because we've seen all sorts of botched executions over the years that have taken place. But even if you could guarantee that death penalty would not be inflict this excruciating physical pain at the moment of an individual's death, you could not guarantee that they wouldn't experience psychological torture, because the whole idea of death threats is that they, by their definition, inflict psychological torture. And in addition, you also have to consider the family members of the condemned inmate. A lot of people think of the death penalty, they always think, well, it's just about the inmate and they've done this really horrible thing in the past. And oftentimes, again, these crimes are horrible. We know, though, that people are also exonerated. We have people that have, in the United States, we've had, I think over 150 people now at this point, we know have been wrongfully sentenced to death who were later exonerated from death row. So we know that mistakes are made. We know that it's racially discriminatory. We know that it's arbitrary. And we also know that you can't eliminate the fact that there's going to be a death threat associated with the use of the death penalty. And because of that fact, I think you have to say that the death penalty is torture. Torture is torture. And if you apply the same definition that's already been used in courts to describe what psychological torture is, then you should conclude logically, and it's most self-evident, that the death penalty itself is torture, is a torturous practice that should be barred. And so I think that the countries of the world, again, redoubling their efforts to abolish the death penalty, which again goes all the way back to Beccaria's time. This idea that we should get rid of the death penalty, we still have it more than 250 years later. But the project that was started in Beccaria's time is one that I think at some point we will see conclude with a recognition that the death penalty violates the prohibition against torture, and that the jus cogens norm against torture should be seen as one that includes a prohibition against the death penalty, in addition to prohibiting all sorts of other, tyrannical practices like mock executions and non-lethal corporal punishments where people are, lopping off limbs and things like that. So, I know I want to leave plenty of time for questions, and have maybe a little bit of a dialogue here. And so maybe I'll end there with my remarks and see what kind of questions people have on this subject or other things you're thinking about.
Well, thank you so much for this wonderful talk, and that's why it was a dream having you here. It's so interesting. It's short-term goal and long-term goal. That's a good plan to talk and think about death penalty. I don't want to ask you anything because just what about the abolitionist movement now? I'm thinking about also the innocence organization, which is an international organization, and we have it still in Italy, but it's not. I don't know what is happening now.
Sure. Let me talk a bit about that. So, I mean, one of the interesting things, actually, before the U.S. Supreme Court, there was a moment where a lawyer representing an individual was basically, that Europe has had this ban on exporting lethal injection drugs. There's a woman in the UK, Maya Foya, who leads an organization called Reprieve, which has worked with the drug companies to actually get them to put in their licensing agreements that you can't use these ordinarily life-saving drugs for purposes of using them in executions. And so there's been a shortage of lethal injection drugs in the United States because they expire over time. And so there's been a lot of pressure put on and the drug companies have agreed now not to really use these drugs. So now the states are trying to get these drugs kind of behind the scenes and maybe through compounding pharmacies that are not regulated as much, where they're essentially mixing their own drugs, which leads to other problems of potential, contamination and also, the infliction of severe pain, physical pain at an execution. But, for the first time in a long time, we really have an organized movement internationally against the death penalty. So there's an international commission against the death penalty. There's which is a leading group that's thinking about globally how to get rid of the death penalty. We have the UN resolutions that come over every couple of years where they're pushing those, and we've seen a increasing number of countries who have joined on to that moratorium resolution over time since they were first passed. I think it was maybe about 15 years ago. We started seeing those moratorium resolutions come into place, and then we have this World Congress Against the Death Penalty every 3 years. It meets in a different place and gets together people that are involved in the anti-death penalty movement. So we have kind of an organized effort at this point. But I would say that one thing is that each individual case points out problems with the death penalty, like wrongful convictions, if there's an innocence issue. And so those cases get a lot of attention. We have cases dealing with racial discrimination. Those get a lot of attention. All of those cases put together kind of shine a light on the death penalty. I think, and in this day and age, right, where we have instant communication, those stories don't really go away, right? They're always there for people to access and see these many fatal flaws associated with the death penalty. So, but I think if people start talking about the death penalty in a different way, instead of, back when I was in high school, the debate again, like I said, was, does the death penalty deter? Does it not deter? When you look at the death penalty through a human rights framework and you look at it through the lens of torturous practices, it's a much different discussion that you're having there. And torture, interestingly, there's no exception. You can't torture anybody. So there's the Torture Convention itself says even superior orders, like in the military, you can't go along with those. You'll still be prosecuted for torture. You just simply can't do. There's no exception to torture. So the idea that, you know, if some academic comes up with some research that says, well, maybe I think that maybe this the death penalty would deter in some way. There's a lot of studies that show actually the opposite. The death penalty actually brutalizes people. But the fact that somebody comes up with some study that purports to show something, that's a piece of paper that doesn't authorize you to torture somebody. And again, the studies are all to the contrary. If you look at in the United States, the non-death penalty states on average have much lower homicide rates than death penalty states. So there's a brutalizing aspect of the death penalty. But I think that, you know, the anti-death penalty movement is both local, individual places, and in the United States, because the Supreme Court now approved the use of executions during the Trump administration. We have 13 people executed. Most of the activities taking place now at the state level. There is legislation proposed in Congress to abolish the death penalty, but a lot of the activities taking place at a state-by-state basis. And the international movement is also, you know, trying to get individual countries like Sierra Leone to abolish the death penalty, which is creating more and more momentum for the cause.
Okay, thank you. I leave the floor to all of you, and don't be shy, please.
I have a question.
Yeah.
Given that the argument, this brilliant argument you have elaborated, do you think that that penalty is unconstitutional according to the US Constitution?
Yeah, I've argued it is, because if it's torture, it's already prohibited by their prohibition against torture, right? So the tricky part is the composition of the court. And so, I mean, interestingly, one of the interesting things to think about, right, is that this lawful sanctions exception, if the US Supreme Court were to say that the death penalty violates the 8th Amendment, then it becomes unlawful. There's no longer any lawful sanctions exception to it, right? So it would immediately be, I mean, and the US Supreme Court would govern the entire country because the 8th Amendment is applied to the states through the 14th Amendment, which there's a due process clause. The 14th Amendment also includes the equal protection clause. So if the US Supreme Court were to declare the death penalty constitutional, that's the only clean way to get rid of the death penalty across the board in the United States, other than, you know, because otherwise you need all these states to pass new laws. And so that's my argument is that the Supreme Court should declare it unconstitutional. They should look at the issue of psychological torture, because when these earlier decisions were decided, that the concept of torture was still seen as one operating principally on the body as physical punishment. But now it's very clear under international law and under, you know, there's a prohibition against mock executions actually in the US code as well, that you need to look at mental or psychological torture as part of this. And if you really examine it, it becomes very clear that this really does constitute a torturous act. And so I think, you know, unfortunately, we've seen the change in the court. So Ruth Bader Ginsburg, who was an opponent of the death penalty, now is off the court. Amy Coney Barrett, who had when she was had written a paper, co-written a paper with somebody about Catholic judges in capital cases, and looked at, you know, how do Catholic judges handle that situation if they personally oppose something. In that paper, that the death penalty was described as an evil, actually, but yet when she got in the court, we see her applying the death penalty and letting executions go forward. So it's unclear if the Supreme Court is going to, you know, you can never predict courts, they're hard to predict, but it doesn't appear to me that the Supreme Court is on the verge of eliminating the death penalty, given the composition of the court. You know, if there had been, you know, different appointees, maybe so, because, you know, again, the Constitutional Court of South Africa, with this long history of apartheid, and the death penalty was used in all sorts of, you know, maniacal ways there, they got rid of the death penalty as a matter of constitutional law back in the mid 1990s. And we've seen other constitutional courts also declare the death penalty to be unconstitutional. So, you know, at some point, I think that will be what the conclusion will be, but I'm just not sure the Supreme Court is quite there yet. So,
because I know there is this leading constitution movement, so they think now we should construe the constitution differently than it was in the past. So when you were describing this kind of punishment, cruel, now cruel means that penalty, But I remember that Scalia's opinion was completely different with the historical construction of the Constitution, and I think the new appointee is exactly in line with Scalia's.
So yeah, the newer appointees are this kind of embrace what's called the originalism, and instead of the living constitutionalism. And again, the first thing you have to think about is with originalism is, you know, you're going back to 17. In the case of the Bill of Rights, 1791, slavery was still permitted. Women could not vote, or in many cases even own property. Women did not get the right to vote in the United States at the federal level until 1920. So you're looking back at a completely different time. And, you know, interestingly, you know, the language itself of the U.S. Constitution, you know, the original language was quite flawed. They allowed slavery to continue until 1808. Actually, there was no prohibition on the slave trade until 1808. Congress did abolish the international slave trade at that time, but we had, you know, overt racial discrimination. We didn't get the 14th Amendment until 1868, which includes now the protection against, you know, the equal protection of the laws, which is, again, the idea of universal rights is built into that. Interestingly, the living constitution idea has also been embraced in the European Court of Human Rights. So in the case dealing with Ireland, what we see there is the court said, well, you know, it could be that what was once considered cruel or inhuman or degrading treatment could at some point be considered torture, because of the development of our notions of protections of human rights. And so I do think it's a flawed method to look back at 1791 when people were using the pillory and things like that as the basis for deciding rationally what we should be doing with our legal system at this moment in time. So I think, but right now there's still a evolving standards of decency concept in the U.S. Supreme Court, where they look at this, so they could still look at that and say, you know, what's the current practice now? But a lot of the new justices have kind of, you know, don't really embrace that idea. Neither did Scalia. So, yeah.
Is there any concern that with outlawing capital punishment in the United States, it would give rise or more ammunition to a pro-life movement outlawing abortion completely, especially with this Constitution?
I don't think. I mean, I think the Supreme Court. You know, there's been this so-called shadow docket, which, you know, and I've just, this new book I'm working, which should be published in December, on private prosecutions. Now, the Senate Bill 8, which is the bill in Texas, which you probably heard about, which basically outlaws abortion starting at like 6 weeks. And authorizes basically bounty hunters to sue for damages for $10,000. That's the basic idea of this law. It clearly violates the Roe versus Wade principle, and the idea that a private citizen should be allowed to sue somebody and violate their constitutional rights is absurd, right? So, you know, I think the abortion issue is really a separate issue. There's attempts now to codify Roe versus Wade at the federal level, but the Supreme Court, you know, does have the final word over this. So we don't know what they're going to do. This shadow docket, what they basically have done, and instead of following the normal process, basically where, you know, cases are argued, but at the trial court level, you have the adversarial system. People, you know, have briefs on both sides. They argue it. It goes up to the Court of Appeals. They have briefs on both sides. They argue it. It goes to the U.S. Supreme Court. They have briefs on both sides. They argue it. We have all these amicus briefs submitted from all the organizations who have an interest in articulating their views. That's the normal way that cases get decided. In this case, what the Supreme Court did was basically just in a very short order, just, you know, in a matter of 72 hours, said we're going to let this law stand, even though in the past, 2 times in the past, they've actually refused to enforce laws. So it's clearly a change in the composition of the court that is driving this issue. And so, you know, we don't know what's going to happen yet at this point, but that precedent goes back to 1973, Roe versus Wade. So it's a longstanding principle. A lot of people have relied upon that, and you know, we now have women traveling to other states to get abortions in the United States from Texas, and Texas is a big state. So
yeah, I would like to ask you, do you think it would be easier to forbid that penalty by judicial decision of the Supreme Court instead of a legislative initiative? Because when you talk about the composition of the court, I thought at the same time the appointment of the judges is made by the president, so the problem would still be political. So maybe a legislative initiative.
yeah, I mean, the death penalty has always been a political and a legal issue at the same time. I think that, I mean, the cleanest way and the only way to really abolish the death penalty for good in the United States is to have the U.S. Supreme Court declare it's unconstitutional. Otherwise, you're going to have continual battles of the state legislatures, and there's, you know, 50 states, right, that you have efforts to reinstate the death penalty, efforts to abolish it, et cetera. One thing that's sort of interesting, though, about this evolving standards of decency concept, which I alluded to earlier, is that the Supreme Court, when they're engaged in that analysis, they engage in a counting of states. Now, it's a strange idea, because normally, you know, the Supreme Court is protecting fundamental rights regardless of whether or not they're popular. So if somebody says something unpopular, the Supreme Court may say, well, you have that's really grotesque what you said, but the First Amendment protects your right to say that. So it's unpopular. But in the evolving standards of decency concept, what the court essentially does is it kind of puts its finger in the air and says, well, which way is the wind blowing? And says, you know, well, we'll protect it if enough states have, you know, already gotten rid of it. So, you know, so for example, the court's decisions that outlawed the juvenile death penalty, they counted states and they said, well, there's a trend that looks like this is going out. And so they said it was unconstitutional, right? So I think that, you know, the more states that abolish the death penalty, then the more likely it is that the Supreme Court itself is likely to say at some point that it's unconstitutional. So imagine this scenario. Like, let's say that all the states in the country except Texas had abolished the death penalty by legislation. Then it would seem very arbitrary, right, to allow one state to use something where it's already been outlawed in other states. So the more states that can be added to the abolitionist column, the more likely it is that the Supreme Court itself will at some point say it's unconstitutional.
Both go.
They're related.
Yeah, it's something made both by the states and by the Supreme Court, because when the Supreme Court realizes that the majority of the states maybe the death penalty, so it can say, okay, let's make this for all the states.
Yeah, so if the Supreme Court rules, because the Eighth Amendment is the 14th Amendment makes the Eighth Amendment applicable to the states, so it sets a floor beneath which no state can go. So if the Supreme Court says it's unconstitutional, then no state can use it, right? Thank you. Yeah. Yes.
I think I'm one of the reason that. But do you think there's that in what I really about this one is you know, the fact that you are restricted to be moved across something like and also have done on side of your kind of psychological.
Sure. So this goes kind of back to the maxim I talked about with, you know, the Beccaria and Montesquieu, that any punishment that goes beyond necessity is tyrannical. I think you have to subject every punishment to that kind of test. Now, there is, you know, some crimes that are so heinous that people feel like, well, they have to have imprisonment as an option. There's been a complete overuse of life without parole in the United States, as an example. I mean, we have cases there where people are, you know, California had this like 3 strikes you're out kind of, people are stealing golf clubs and then, you know, they end up with a life sentence, you know. So I think, and there's an organization called the Sentencing Project, which I'd encourage you to look at, where they showed the statistics on this. And it's something like, I mean, it's a huge number of people who are serving life without parole sentences in the United States. Now there's some cases in the US where they've said for juveniles, and actually the UN Convention on the Rights of the Child prohibits both the death penalty and the use of life without parole for juveniles. So it's Article 37 of that convention, which says that you can't use either one of those for juveniles. That you have to give people some prospect that they could potentially get out. Doesn't mean that they won't necessarily serve a long sentence, but it means that they have to have that opportunity to show that they should be eligible for release. So there has been, and there's some Supreme Court cases on the juvenile issue in the U.S. which have talked about that as well, where kids they got sentenced are now getting hearings about whether or not they could be eligible for release. Beccaria in his book, talked about the difference between, and again, he called it perpetual slavery, which is, a whole different idea. The idea that it would be more effective to deter if you had somebody who was seen to be suffering the consequences in prison for a period of time, as opposed to executing somebody and have that momentary, execution, that would be a more fleeting thing for deterrence purposes. Now, again, I think that the life without parole aspect, in terms of being practical, we may need to have that as an option for some offenders that they've committed particularly heinous crimes. Otherwise, the public may not accept that. But I think that it's a little different than the torture that involves that immediacy of the death threat itself. But I do think that life without parole has been completely overused in the way that it's been administered. It's almost like people have used it as a first resort. And actually ironically, in some of these death penalty states, Texas was the last state to go to a life without parole. They actually had a moment where they were not wanting to put in place life without parole because they wanted to give jurors that sort of Hobson's choice of either you're going to send somebody to the death row or you're going to give them a sentence that the jury didn't feel was adequate to the punishment. And so, now all the states in the U.S. have actually the option to have a life without parole sentence, but I do think it's been completely overused. And that study that was done by the Sentencing Project really illustrated the fact that it is overused in the U.S. I know in Europe, it's not anywhere close. And in fact, if you look at the Rome Statute, and this was maybe a point I also could have made in the talk, the Rome Statute set up the International Criminal Court. In the Rome Statute, the death penalty itself is not authorized. So the death penalty currently under international law is not authorized for genocide, crimes against humanity, war crimes. The statute talks about a 30-year sentence, but there is an option in exceptional circumstances to go with a life sentence. So there's the option under international law for that. But again, the use of imprisonment does not involve the same kind of psychological immediacy of the fear of a death threat. So it's a little different in that way, but I do think it's something that you have to look at each individual case. And like solitary confinement is an example where, again, some states in the U.S. have used automatic solitary confinement for death row inmates. And to me, that doesn't make any sense, that they would automatically apply that punishment. You're isolating somebody in their own cell, sometimes for decades at a time. There was one inmate who literally gouged his own eyes out. I mean, it was a incredibly inhuman, torturous, punishment to inflict on somebody. There's a UN report that talks about no more than 15 days, that prolonged solitary confinement is almost inherently a torturous thing. So I think the idea of torture has to be applied to different ideas, but there's different analysis for the law versus the facts of a given punishment that you have to look at, I think.
Going back to the university rights, do you think that the simple fact of knowing that that penalty participate in other states is a torture in itself?
Say it again.
The fact that knowing that that penalty is not possible in other states is a torture in itself?
So the death penalty not being it's not authorized in Italy, right? So but do the Italians talk about the death penalty as being a torturous act?
Yeah, but what I meant was for an inmate like the United States, knowing that you will not be sentenced to death penalty in another state, isn't that a form of torture itself? Just knowing that there's a difference based on where you live.
There is actually in the, it's an interesting question. So, and thanks for clarifying that. So in the Torture Convention itself, it also prohibits torture on the basis of discrimination. So now that might normally be seen as a, and I have to look back at the history of that provision, but my guess is that was more targeted at like racial discrimination. So in the US, in the system of federalism we have, normally there's states have the right to do their own, punishments and things like that. But where the US Supreme Court has gotten involved is to say, well, if enough states have moved away from a certain punishment, then we're going to say that you can't use it anywhere. And so until that moment happens where the Supreme Court weighs in, it's really up to the states to kind of set their punishments. Now, there's also some interesting US Supreme Court case law existing that has defined what an Eighth Amendment violation is. And I'll give you some examples of what the court has said Eighth Amendment violation is. So if a prison guard gratuitously beats up an inmate, that is considered to be an Eighth Amendment violation. If an inmate was put in a cell with somebody who smoked 5 packs of cigarettes a day, the court said you could sue for violation of your Eighth Amendment rights in that situation. So exposure to secondhand smoke was considered an Eighth Amendment violation. There was another case called Hope versus Peltzer, where the Supreme Court ruled on a case where a person had been on a work squad and had been basically handcuffed or chained to a hitching post and let out was in the hot sun for 7 hours, got dehydrated and sunburned. The US Supreme Court said that was an obvious Eighth Amendment violation. So again, these are all things that don't involve the death of somebody, but the court has used the Eighth Amendment to protect people from these harms. And so what I like to, when I talk about the Eighth Amendment, and again, I don't know how many of you studied the US Constitution before? Have you had a comparative law class, or a few of you maybe? But the Eighth Amendment has this kind of, to use a more universal reference, kind of a Dr. Jekyll and Mr. Hyde kind of aspect to it. Because on the one hand, it's this protective thing. It protects you from being assaulted in prison, from being raped in prison, protects you from inmates who are smoking in prison, right? But somehow it doesn't protect you at the moment you're executed. So it protects you all the way up to the moment you're executed, and then somehow the protection disappears at that point. And that's also it's such an incongruous and unprincipled application of the Eighth Amendment. That's why if you say the death penalty is torture, then suddenly you actually have a principled Eighth Amendment that protects people in a universal way from those kinds of harms. So, so that's kind of, the way I think about it, but the Eighth Amendment's kind of an enigma in that way, because it's conflicting, because it both protects, but then it doesn't protect at the same time at this point, at least as interpreted now. Yeah.
I have a question about the relation between, for example, the European Union the guide of the European Union, France will succeed to Slovenia to the guide of the Union. Instead of claiming that the French government will use its 6 months of presidency to go against the use of death penalty. What about the international legal relations between, for example, the European Union, which is a strong supporter of abolition of the death penalty, and such close, strong partner of such practices where death penalty is still present in
In terms of the relationship between the United States and the European Union?
Exactly. So close partners, but which is such great diligence and such.
Right. So obviously there's a lot of economic ties between the European Union and the United States. I think, the European Union has actually gotten involved in some cases. They've actually submitted some briefs, and there's been some arguments that have been made before the Supreme Court, actually, and this is not just the European Union. Australia has also expressed some interest in this, and there's some other places around the world that have gotten involved in trying to influence. And I think it does make sense for countries to put political pressure on other countries as part of the, that's part of the diplomatic, sort of, ongoing discussions that take place. And so I think it's appropriate for people to raise the issue of the death penalty in their international, relations with people. This is certainly something like, if you look at a place like China, that you would want to see that raised, continually, that the human rights violations there. And obviously China is executing a whole lot more people than the United States is, but yet this is something that's still going on in the US as well. And I think that the US would actually have more leverage internationally in terms of human rights if they were to abolish the death penalty, because then they have more sort of moral authority to go to another country and say, you can't be doing that to people. Because a lot of executions are also being of, political prisoners, and, they're done for political reasons. Political opponents are executed. I mean, in Russia, there's the use of just sort of, they're not using the death penalty, but they're using extrajudicial killings, to kill people. So I do think it's an important issue, but I think the important thing is also to kind of elevate the legal discussion of the way we talk about the death penalty, so that it's not, seen as just a policy difference, that there's some policy difference, but to actually think about the law in a way that is honoring the idea of universal rights and protecting rights universally, and trying to think about the death penalty in that context, in terms of it being a violation of human rights, as opposed to just, well, you have a difference of opinion about whether it deters crime or not. That's a different way of looking at it, I think. So my focus is, with my research, is try to really look at this through the framework of the human rights system itself, and the existing prohibition against torture. It's just that the death penalty has been under conceptualized as, so it's somehow seen as something other than torture right now, but it really should be seen as again, under this umbrella of torture. And the more people raise it in that way, I think the more it's stigmatized in the international legal system, and the more you're likely to see judges move away from that. I know that, like, Justice Breyer, for example, is written a book called The Court and the World, The Court and the World, which is looking at international law, how it impacts. And Justice Kennedy, before he retired, was also very much coming to Europe, studying issues there, and wrote some opinions that that at least got rid of the death penalty for certain categories of cases. So the more people talk about it in the international system, I think the better off we'll all be.
This is the last question, because we ran out of time. Okay.
About a principle that is expressed in the Italian Constitution, which has to do with the necessity to educate somebody who has been condemned for a crime. So during his imprisonment period, he should be re-educated and somehow yes, the nation should yes.
In the same manner, he went into, yeah.
So I would like to ask if in comparison with the US Constitution, which does not include such a principle, in comparison with the other constitutions that do not include principle, is this seen by somebody who comes from the United States, or maybe from somebody who not as too optimistic, or is it possible to
Yeah, I mean, I'm always optimistic. So I think, in education, hopefully that's why you're all here, is something that you want to be all get better educated on issues. I think, the US Constitution is one of a kind of negative rights. It kind of prohibits people from being, having the coerced confessions and unreasonable searches and seizures. And there's not a lot of positive requirements in terms of that, unlike like the South African Constitution has kind of a right to housing, right to, healthcare. It's worded a lot differently. And part of that's because of the age of the Constitution. It's just, the Constitution was obviously drafted in the 18th, century. But I do think, it's good to be trying to rehabilitate it, and maybe to, kind of bring it back to Beccaria. That was seen as in the Enlightenment principle, the whole idea was that you're trying to prevent crime in the future. And so he talked about it in his own book, about education and the power of education. So I think that the more people get educated, the less likely you're to have, horrible crimes, because we know there's a relationship between poverty and crime. And the more educated people become, the less likely they are to want to engage in criminal activity, right? Because they have options. When you have extreme poverty, people sometimes don't have a choice. A lot of the executions that took place in England because people stealing bread or things like that, they literally couldn't afford to live. And so if we have society put people in a place where we're giving them opportunities, education, economic opportunities, you'll see less crime overall. But I do think for prisoners, there should be opportunities. And one of the things that, so concerning to me from like the US perspective is we've had in the last couple of decades, we've had the use of private prisons, which if you're running a private prison, your goal would be to fill up the prison to make more money. And that should not be the goal of a prison system. The prison system should be to rehabilitate and to make sure we're not seeing people a second time once they actually do get out of prison. So.
Yeah, there are a lot of questions and things to ask, but we'll leave them for the next chapter. So I think we must finish here because we've run out of time. And but before I let you go, please let's give a big thank you to John Besler. Thank you so much.
Thanks for your time. We appreciate your listening.